Good morning, Your Honor. May it please the Court, Ben Chu for Plaintiff Johnny Depp. It's just still morning. Your Honor, if I may approach.
All right. Thank you.
Thank you, Your Honor. I've just handed to Mr. Rottenborn and Your Honor an opposition that we prepared before we had the benefit of seeing Ms. Heard's affirmative motion to strike, but I think we've anticipated the arguments made, such as they are. The Court should deny Defendant Amber Heard's motion to strike because Mr. Depp has come forward in his case in chief with multiple credible witnesses, documents, and authentic tape recordings of Ms. Heard herself, not only satisfying all of the requisite elements of his claim for defamation, including actual malice, but also going the extra mile of showing that Ms. Heard physically abused him. She's the abuser in this courtroom. Your Honor, going back to the standard, as Your Honor is well aware, in considering a motion to strike, the trial court must view the evidence and all reasonable inferences drawn from the evidence in the light most favorable to the plaintiff. Any reasonable doubt as to whether the plaintiff has produced sufficient evidence of the wrong alleged must be resolved in the plaintiff's favor and the motion to strike denied, unquote. And that's the Boeing case, I believe Mr. Rottenborn referred to, 243 Virginia 81 at 81, 1992. Quote, the weight and credibility of the testimony of witnesses are solely matters for the jury. The jury may accept that part of the testimony it believes and reject that which it does not. It is also within the exclusive province of the jury to draw any reasonable inferences from the evidence before it, citing Rate versus Minix, 275 Virginia 579 at 585. In deference and respect to the court's time, Mr. Depp incorporates by reference the legal analysis set forth in the court's opinion letter dated March 27, 2020, overruling Ms. Heard's demurrer to the 3 defamatory statements at issue. And that letter opinion is attached as Exhibit 1 to Mr. Depp's opposition. That's where the court fulfilled its proper gatekeeping role that Mr. Rottenborn referred to. As a threshold matter, the elements of a defamation claim are the following. Publication of an actionable statement with the requisite intent, citing the Shaker versus Bonfault case, 290 Virginia 81 at 91. As to damages, they are presumed here because Ms. Heard's false allegations of domestic abuse, sexual assault, and rape constitute defamation per se, citing the Tronfield case, 272 Virginia 709 713, a 2006 case. As the court noted at page 3 of its opinion letter, typically an editorial or op-ed column is ordinarily not actionable because it appears in a place devoted to or in a manner usually thought of as representing personal viewpoints. However, Virginia recognizes that, quote, a defamatory charge may be made by inference, implication, or insinuation, citing the Carwell case. And a statement expressing a defamatory meaning may not be apparent on its face, citing Pendleton, with which the court is quite familiar, 290 Virginia at 172. Accordingly, in order to render words defamatory and actionable, it is not necessary that the defamatory charge be in direct terms, but may be made indirectly, and it matters not how artful or disguised the modes in which the meaning is concealed, if it is in fact defamatory. Carwell, 196 Virginia at 7. And based on the authority and reasoning set forth in pages 4 through 8 of the opinion letter, the 3 statements at issue are actionable under a theory of defamation by implication. Mr. Depp established in his case in chief that Ms. Heard in fact made all 3 of the defamatory statements at issue. As the court admitted into evidence as Plaintiff's Exhibit 1, the op-ed Ms. Heard published in her own name in the Washington Post on December 18, 2018. And let's take the three statements and the proof that has been adduced. Statement number one, Amber Heard, quote, "I spoke up against sexual violence and faced our culture's wrath. That has to change." Per page 6 of the opinion letter, the first statement could reasonably convey the alleged defamatory meaning, i.e. that Mr. Depp abused Ms. Heard, to its readers without extending the words beyond their ordinary and common acceptation. See Pendleton 290, Virginia at 172, also citing the Carwell case. Resolving every fair inference in Mr. Depp's favor, this statement could reasonably imply that the sexual violence Ms. Heard spoke up against was in fact perpetrated by Mr. Depp. Mr. Depp produced several credible witnesses and documents proving that Ms. Heard was implying that he committed sexual violence against her. Mr. Depp himself testified to that, as did his sister, Christy Dombrowski. Mr. Depp's former agent, Christian Carino, testified that, as did his current agent, Jack Wiggum. But perhaps most convincing of all, and most disgusting of all, was the testimony of the ACLU's Terrence Doherty, a lawyer nonetheless. Mr. Doherty testified, among other things, that when they were pitching the op-ed to the Washington Post, they stated, "Hey, Michael, wondering if we might interest you in a piece by Amber Heard, who, as you may recall, was beaten up during her brief marriage to Johnny Depp, on what the incoming Congress can do to help protect women in similar situations." Mr. Doherty also testified that everybody understood, as Ms. Heard and the ACLU clearly intended, that this statement and the other two statements referred directly to Mr. Depp. Quote, "This is an article that was in USA Today and specifically ties Amber's statement in her op-ed piece to Johnny Depp." And when Jessica Weitz, who actually wrote the op-ed that Ms. Heard later adopted, she says, quote, to Mr. Doherty, "So much for not mentioning JD," when the USA Today made clear that they, like everybody else who read the op-ed, understood that, as Ms. Heard clearly intended, it referred to Mr. Depp, which makes her Instagram post 2 days before the trial began, that she didn't mention Mr. Depp, all the more outrageous. Your Honor, there is Ms. Schulman, also of the ACLU, acknowledged that Ms. Heard's op-ed referred to Mr. Depp. So it's very clear that the ACLU and Ms. Heard intended. That was the whole purpose of this, so that they could get interest in this and it would coincide with the premiere of Aquaman, because otherwise no one would have been interested in anything written by Ms. Heard. Mr. Doherty also testified that Ms. Heard only paid 1.3, actually she didn't even pay all that, out of the $3.5 million that she had pledged to the ACLU, and then they helped her lie about it. And it's one thing, Your Honor, for her to stiff the ACLU, which frankly played a reprehensible role in this case. It's quite another for her to fail to honor her obligation to the Children's Hospital of Los Angeles with sick and dying children, and that she failed to do as well. And as Your Honor has mentioned, the fact that she put her name on that article means that she is responsible for all of those statements, which she specifically adopted later. And I'll go through the other two statements quickly, Your Honor.
Well, can we stay on this one for one moment, though?
Yes, Your Honor.
Because do you agree that the only evidence before that we've heard in this trial, as far as the title of the op-ed, is that even Mr. Doherty, I believe, testified to it, that it was something that Washington Post wrote?
Well,
for the one online.
He's not our witness, Your Honor. That's a witness from the ACLU.
Well, I understand, but it's the only evidence I have.
I respectfully disagree, Your Honor.
All right.
What the only real evidence Your Honor has is Plaintiff's Exhibit 1, which is Amber Heard putting her name on the entire article, including the title. That is the only evidence before you. The ACLU was a co-conspirator with Ms. Heard, and whether they say, oh, maybe the Washington Post wrote it, that's not the end of the story. All she has done is create an issue of fact as to whether she wrote the title or not.
So you're saying just having that exhibit in evidence is enough?
Absolutely. Absolutely, Your Honor. Her name is on the article.
Okay.
What does an average reader expect? So that alone is sufficient to beat a motion to strike. If they want to come back later and say, gee, she didn't write the title, as if that were a defense, I hope they make that argument. I hope they make that argument to the jury, because it's about as credible as her argument that, oh, I wasn't referring to Johnny Depp. She didn't have to. And the testimony of Terrence Doherty was very clear that when they took out the references to Johnny Depp, no one was interested in this article anymore. So she said, put it back in, make it more spicy so people would read. Otherwise, she couldn't get it in the Washington Post. It would be back in Teenage Vogue, which is the other publication that was considering publishing it, because no one was interested in what she had to say unless she was defaming Mr. Depp. But if I could go to the second statement, I'll try to be quick, Your Honor. 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out. As for the second statement, defendant called herself a public figure representing domestic abuse, which can be read to imply that she became a representative of domestic abuse because she was abused by Mr. Depp, not just because she spoke out against alleged abuse. This inference can be drawn without extending the language beyond its ordinary common acceptation, citing Carlisle, 196, Virginia at 8. Your Honor, quote, to constitute a publication, it is not necessary that the contents of the writing should be made known to the public generally. It is enough, it is said, if they are made known to a single person, unquote, citing Snyder versus Fatherly, 158, Virginia, 335 at 350. Everybody and his grandmother testified that Ms. Heard was referring to her bogus ex parte TRO that she obtained on May 27, 2016. And it was interesting that Mr. Depp's own lawyer said that she wasn't even provided notice. So Ms. Heard made very sure that Mr. Depp wouldn't have notice of the ex parte TRO. And Ms. Heard herself, the evidence shows, knew that Mr. Depp, having just suffered the loss of his mother, was already on the other side of the country, was already in New York at the time of this TRO, and was heading to Europe for several weeks. So she knew she didn't need any protection from him. This was just a scam for her to get the $7 million in the divorce settlement that she said she gave to the ACLU. She swore she gave to the ACLU and the Children's Hospital of Los Angeles, and she pocketed instead. Mr. Depp, Ms. Dombrowski, Mr. Carino, Mr. Wiggum, and the inimitable Mr. Doherty of the ACLU, which lent its once respected name to Ms. Heard's defamation. So while Ms. Heard may have avoided any direct mention of Mr. Depp's name, there is extensive testimony and evidence in the record showing that the implication of her op-ed could not be more clear, i.e., that Mr. Depp abused Ms. Heard during the course of their marriage. Under Virginia law, quote, it is not necessary that the defamatory charge be in direct terms, but it may be made indirectly, and it matters not how artful or disguised the modes in which the meaning is concealed if it is in fact defamatory. Citing Carlisle, well, we can argue as to how artful it was, but the implication was very clear, as the court has previously ruled, or not law of the case, but as the court has persuasively written in its opinion letter. Let's move to the falsity of Ms. Heard's ever-evolving and ever-escalating change of IPV and sexual assault. Mr. Depp's sworn denial is all he needs to survive a motion to strike, but there's a lot more than that, Your Honor, and I'll try to be brief. 3 police officers, actually 4, but the 3 who testified already, Officers Sines, Haddon, and Gatlin, testified unequivocally that Ms. Heard did not have a mark on her on the evening of May 21, 2016. And I could go through, I'll just go through very quickly. Officer Haddon, strike that. Officer Melissa Sines on jury trial day 10. Question, did you provide a copy of this pamphlet to Amber Heard? Answer, I did not. I didn't identify her as a victim of domestic abuse. The next day, Officer Melissa Science. Okay, at this time, did you notice any injuries on Ms. Heard? Officer Science, I did not. Question, okay, were you looking to see if she had any injuries on her at the time? Officer Science, yes, I was. Question, and so you were looking to see if Ms. Heard had any injuries and you determined that she did not. Is that accurate? Officer Science, correct. Question, okay, and was the lighting good enough in the hallway for you to make that determination? Answer, yes, the hallway was well lit. Officer Gatlin's testimony was the same, and he had the body cam. Officer Haddon's testimony was the same. The testimony of nurses Debbie Lloyd and Erin Borem, who, like the police officers, did not work for Mr. Depp. In fact, they worked for Dr. Kipper, also belie Ms. Heard's false allegations of abuse. Isaac Baruch and Alejandro Romero both testified that they saw Ms. Heard repeatedly and in the clear light between May 21, 2021, which was the last time Mr. Depp saw her before leaving on the Hollywood Vampires tour. The next time he was to see her was when Ms. Heard begged him to come see her in San Francisco, which is hardly the act of a domestic abuse victim. So we have Isaac Baruch and Mr. Romero saying that they saw Ms. Heard repeatedly in the interval of time between May 21 and May 27th, when she obtained the farce ex parte TRO, and they saw no marks on her face and no swelling. Two witnesses, Mr. Baruch and Brandon Patterson, saw the video of Ms. Heard and her sister Whitney pantomiming the fake punch after this alleged incident of abuse. Ms. Heard's former personal assistant, Kate James, and several other witnesses, including Dr. David Kipper, saw no violence by Mr. Depp and no injuries to Ms. Heard. Indeed, witness after witness has come forward to testify that Ms. Heard, far from being a domestic figure representing domestic violence, unquote, is in fact a recidivist perpetrator of domestic violence on Mr. Depp and others. We have the testimony, the harrowing testimony of Mr. Depp himself, who described several witnesses. One, as Your Honor will recall, when he was hiding in the bathroom after escaping one of her attacks, and she claims to have hurt her foot kicking the door. Mr. Depp opens the door to see if she's hurt, and then she kicks the door in on him and punches him. We have the incident of December 15, 2015, when Ms. Heard threw punches at him wildly at the back and side of his head. Mr. Depp testified that he ducked and covered to protect his face. Eventually, he turned around to grab her and stop her arms from flailing. December 15 in the Bahamas. During an argument, Ms. Heard grabbed a can of mineral spirits and threw it at Mr. Depp's face, striking him in the forehead, bridge, and nose area, and the jury saw a photograph of the bridge on the bruise of his nose. We have testimony from Mr. And by the way, Tara Roberts, who is the manager of the island, confirmed that the incident with the mineral spirits. You have Mr. Depp's testimony of what happened on April 22nd, 2016. And we've heard testimony today from Erin Borem-Filati that Mr. Depp was very responsive, was very sociable, was not in any way inebriated that day when Ms. Heard says he was, and she attacked him that night as well. And I'm getting to the end of this, Your Honor. We have Ms. Heard's own admissions. We have her admitting to hitting Mr. Depp, and her only contention was that she wasn't punching him, she was just hitting him. We have testimony from Travis McGivern that on February 23rd, 2015, Ms. Heard threw and hit Mr. Depp with a can of Red Bull and then sucker punched him with a closed fist. Finally, we have the rather stunning testimony of Ben King, quite a credible witness who accompanied Ms. Heard on the flight back from Australia, where Ms. Heard admits to him in a rhetorical question, quote, "Did you ever totally lose it on someone you love?" Which was, we would respectfully submit, an admission of her severing the top or the tip of Mr. Depp's finger. Finally, Your Honor, statement number 3, quote, "I had the rare vantage point of seeing in real time how institutions protect men accused of abuse." Again, quoting very briefly from page 7 of the court's opinion letter, quote, "Drawing every fair inference in plaintiff's favor, the court can fairly conclude that defendant's statement that she saw how institutions protect men accused of abuse could reasonably convey to its recipients that she saw how Mr. Depp was protected by institutions, that he abused her and spoke up against it." Your Honor, again, we have multiple testimony from multiple people, including Jack Wiggum and all the others mentioned, that this was a reference to that. Your Honor, again, the lies that have already been exposed that Ms. Heard has told about the charitable contributions, the incidents in this case, and again, I'll just cite a couple of more, the testimony of Isaac Baruch. When Mr. Baruch saw Ms. Heard on June 3, after she'd gone through with the sham ex-party TRO, and Mr. Baruch was asked, did she say anything in response? And Mr. Baruch testified, yeah. In response to that, she, meaning Ms. Heard, looks at me and said, "I told Johnny I don't want anything. The lawyers are making me do all of this." And that's what she said. Well, the lawyers are making her do all of that. And apparently she wanted the $7 million for herself. She even lied about the final insult left on the marital bed after her 30th birthday party. And it was quite telling that she admitted to Starling Jenkins, a former United States Marine, that this was a terrible prank gone awry. Well, she lied about that too. In fact, she said Mr. Depp was crazy to even allege that she could have done such a thing. Well, she admitted it to Mr. Jenkins. Per Tronfield, as cited earlier, Mr. Depp does not have to prove damages because this is defamation per se. In fact, these involve some of the most heinous crimes any man or woman can be accused of. However, he has done so. Jack Wiggum tested yesterday that the impact of the op-ed was catastrophic on Mr. Depp's personal and professional life, that it was a $22.5 million loss on Pirate 6 and another $20 million on others. We've had the testimony, so we had Mr. Wiggum testifying as to the 22.5 lost on Pirate 6 and another 20 lost on the other films, the other studio films, the indie films, and the other ways Mr. Depp would have made income. We have Richard Marx's testimony, Douglas Banya's testimony, and the testimony of Michael Spindler just this morning. Finally, Your Honor, none of Ms. Heard's affirmative defenses, which would include, her trying to create an issue of fact on the title, can support a motion to strike, as to which she bears the burden of proof of her affirmative defenses. Quote, "Whether the defendants have met their burden cannot be resolved when considering a motion to strike." See 243 Virginia at 83. And just to respond to Mr. Rottenborn's citation to the Lacova case, which we hadn't seen until he mentioned it today, I would only note, Your Honor, that defendant admits that she tweeted a link to the online version of the op-ed at paragraph 97 of her answer, though again, the admission of Exhibit 1 is more than enough to survive the motion to strike. And the Lakova case at 995 F. 3rd 134 holds that republishing a hyperlink doesn't necessarily start the statute of limitations, not that a hyperlink cannot be defamatory. So with that, Your Honor, we respectfully request that the court deny the motion to strike in full, and let's hear from Ms. Hurd.
All right, cross-examination.
Thank you, Your Honor. Good morning, Dr. Hughes. I'm Wayne Dennis, and we haven't met before.
No, good morning.
Good morning. You testified yesterday that you have to give careful attention to gendered stereotypes, correct?
That is correct.
When you're talking about intimate partner violence, you have to pay attention to gendered stereotypes. And during your testimony, you in fact paid attention to gendered stereotypes, correct?
I'm not sure what you mean.
Well, you said we were going to have to pay attention to gendered stereotypes, and then you testified at length where you referenced both men and women. You paid attention to those stereotypes during the course of your testimony, correct?
What I was saying was you have to pay attention to gendered stereotypes when you're conducting these evaluations. You can't assume all the time that the male is the perpetrator and the female is the victim. You have to go into the evaluation understanding that the male also could be the victim of intimate partner violence.
In fact, you're aware that there are large-scale studies that do say that IPV towards males does exist.
Of course.
Okay. And every time you referred to the characteristic of a victim of intimate partner violence yesterday, you used the pronouns she or her, didn't you?
I was using the she and her pronouns in this case because my determination was, as I stated, that Ms. Hurd was the victim of intimate partner violence. That is why I was using the she, her pronouns.
You, in fact, said women gets into the relationship for all the right reasons. That's what you said. The woman gets into the relationship for all the right reasons. And then you say difficult for victim to extricate herself. You go on to say that she can and she should. Over and over, you use she, right?
I believe in this case I did because I was referencing this case where I found Ms. Hurd to be the victim of intimate partner violence. It doesn't mean that men don't get into the relationships for all the right reasons too. I believe they do.
Nearly every time you referenced the perpetrator of IPV, you used he or him, didn't you?
And it goes back to the same reasoning as I'm describing my understanding and my evaluation in this matter. Of course, men can be perpetrators and victims of intimate partner violence. That's well established in the research, and that's well established in my clinical practice as well.
Isn't the reason that you used the pronouns that you did that you almost always testify on behalf of a woman?
That's not correct.
You don't even remember the last time you testified on behalf of a man.
Well, I don't testify on behalf of someone. I testify as to the results of my evaluation. I frequently treat and assess male victims of childhood sexual abuse who are coming into treatment for abuse by their Boy Scout leader, by their coach, by their teacher, by a trusted adult. I see them in therapy. I see them in forensic matters, in criminal cases. So I treat and evaluate men all the time.
I didn't ask you about treatment. I asked you about testimony. You broke out your practice between treatment and testimony. I'm not asking about treatment. When's the last time you testified on behalf of a man?
I testified recently in a deposition on behalf of a man who was traumatized because he was wrongly convicted.
At the time of your deposition 6 weeks ago, you couldn't remember a single time you had testified on behalf of a man.
I testified in my deposition that I testified in a case of a man who was wrongly convicted about 20 years and suffered physical and sexual violence in prison, and I detailed the traumatic effects of that happened on that gentleman.
All right. Why don't we take a look at your deposition?
Sure.
All right. Transcript of the deposition that you gave March 28th, 2022, correct?
Yes.
All right. Let's go to page 77. Page 78, line 8. So you can't recall a single instance where you were hired by the attorney representing the male in an IPV matter, correct?
In an IPV matter, not in a trauma matter or a child sexual abuse matter.
Okay, so that's the distinction. You don't have any recollection of ever testifying on behalf of a male in an IPV matter.
As I stated yesterday, the very first case that I testified in was in a same-sex intimate partner violence where the man was the victim of another man. I routinely treat and assess same-sex couples where then the female can be the perpetrator of another female, and the male can be the perpetrator or a victim of his partner.
So let me get this. You testified in a case where one male is alleged to have engaged in IPV against another male.
Correct.
All right. Okay. But that's the only one you remember. That's the only one you remember.
No, I've done this frequently. As you well know, most cases don't go to trial. I've worked on hundreds and hundreds of cases. You've limited to testimony. Many cases don't come to trial, but I've issued reports and worked on many cases of same-sex intimate partner violence where men are the victims.
But I did ask you about testimony, and I limited the question to testimony, and the only testimony that you remember is the same-sex couple, right?
There were multiple same-sex couples, I believe, that I testified
That you
in.
testified in court at trial.
I believe so, yes.
All right, but you didn't remember that in March.
I did remember that in March.
Okay. How'd you get engaged?
Engaged?
How'd you get hired to do this work?
I was contacted by the legal team.
All right, were you interviewed by her legal team as to whether you were going to testify here?
I was not.
You were not interviewed.
I was not.
You were contacted.
Correct.
Had you worked with that legal team before?
I had.
Yeah. So they already knew who you were, right?
Correct.
Right. And at any time that you were working with Ms. Hurd or assessing Ms. Hurd, she could have chose to fire you, correct?
I suppose her legal team could have chose to fire her. I was not her. She is not my client. The legal team is the one who hires me. I am responsible to the legal team, not Ms. Hurd.
And the legal team that hired you already knew who you were because you worked together previously.
And clearly they knew of my expertise in this area of intimate partner violence and traumatic stress, which is why they contacted me to work on this matter.
You talked to Ms. Hurd for, what, approximately 30 hours, right?
Correct.
How long have you spent with Mr. Depp?
I did not spend any time with Mr. Depp. It was my understanding that he did not sit for a psychological evaluation.
Right. In fact, you never met Mr. Depp, have you?
I have not.
But you purport to be able to assess the relationship between Mr. Depp and Ms. Hurd?
But I also read Mr. Depp's transcripts of his testimony. I watched his deposition testimony. I reviewed his medical records. I reviewed his text messages. So it's not necessarily totally blind. I did have information, although I'm not making a conclusion about Mr. Depp himself.